So we've been talking about the notion of property rights as being about dominion over one's land or personal property. And nested in this idea is this notion of one of the fundamental aspects of ownership interests is the right to exclude, the right to keep someone from using your stuff or coming onto your land without permission. And a strong example of a court vindicating the right to exclude comes from a case called Jacque versus Steenberg Homes. Now, in Jacque, the defendant, Steenberg Homes, was delivering a mobile home, and the route to deliver the home was extremely inconvenient, and the easier way would be to cut across the land of the plaintiffs, the Jacques. And the Jacques, however, just basically said, no, you can't do that. Steenberg Homes offered money, they tried to negotiate, and the Jacques just simply said, no, you can't do that. And Steenberg Homes went ahead and they trespassed anyway. And the damages assessed in that case were $1 of actual damages. And I suppose there was also a $30 fine from the local sheriff's department. But in terms of damages for the Jacques, it was just $1 in actual damages and $100,000 in punitive damages because they deliberately trespassed across the Jacques' land. And the question for the court in the case is whether or not a punitive damages award that large can be supported by such a small actual damages figure. And the state Supreme Court said, yes, it can. We hold that nominal damages may support a punitive damage award in an action for intentional trespass. This was not an inadvertent trespass. This was deliberate. And so what's the rationale for the court in so strongly vindicating the right to exclude? The court looks at things from both the perspective of the plaintiffs and society in general. For the Jacques, the court says, look, the right to exclude is important, but hollow if the legal system provides insufficient means to protect it. And so there's a certain amount of question begging there, right? The idea of the right to exclude as being particularly important. But then the court goes on to say that society in general has a strong interest in deterring intentional trespass. For one thing, we want to preserve the integrity of the legal system. If landowners can't count on their rights being protected, and a $1 actual damages award is probably not going to count as protection of one's rights, then they may not trust the legal system to vindicate those rights, and that opens the door to the possibility of property owners resorting to self-help, what I like to call the 12-gauge solution. If the law isn't going to protect your interest, then you may take the law into your own hands, and that's an invitation to violence. Now, that isn't to say that there aren't some nice questions about alternative facts. It seems clear that the court is not particularly sensitive to the need for Steenberg Homes to avoid an inconvenient route for the delivery of their mobile home. This is not the kind of thing that strikes anyone as an emergency. They could have scouted out the route in advance. To the extent that there were delays, they could have built the cost of those delays into their delivery contract. But we could possibly imagine a very different situation if, say, instead of being the delivery of a mobile home, it was a speeding ambulance that had to rush a person with a heart attack to the hospital in an emergency situation. But that's not the situation we have here. The other interesting thing about the court's reasoning, though, is to think about its impact on the market. That is, even though the Jacques are refusing to participate in the market in this case, that is, they were unwilling to negotiate for a price to give Steenberg Homes permission to cut across their land, or at least that's how it appears on the facts as recited by the court does raise the question of, without there being punitive damages, what is to stop Steenberg Homes from concluding in the future that delivering its mobile homes via an intentional trespass and paying the resulting forfeiture, what is to stop them from concluding that that is not more profitable than obeying the law? And in that situation, who would be setting the value of property rights? It would no longer be the owner of the property, but rather a third party, rather the court, rather the state. And so what's kind of interesting about Jacque versus Steenberg Homes is that it has built into its rationale a background presumption of a market economy. That is, prices not being set by a state, but rather prices, as at least as an initial matter, being set by private actors in negotiations with each other. And so it's kind of interesting because, again, the Jacques did not want to participate in that system in this particular case. But in order to vindicate that system, it becomes necessary to bring out the punitive damages stick against Steenberg Homes for their opting out of the underlying legal rules. So to conclude, Jacque shows a very powerful vision of the importance and centrality of the right to exclude to property law. And so in the next video, we'll have a very different case presenting a different vision of the importance and power of the right to exclude arising under quite different circumstances.